love, and respect. Have faith that the light of God's unconditional love burns brightly in every one of our hearts and will give us that strength and that clarity and that true happiness that we seek, and that He will guide us every day, every step through these dark times to the bright future that our founders envisioned for our great country. Let us never forget, we belong to God and to no one else. And by God's grace, we are free and we will remain free. Thank you all so much. God bless you. God bless America. Aloha. Thank you.
Ladies and gentlemen, please welcome the Executive Director of the North Carolina Faith and Freedom Coalition, Jason Williams.
Man, it's great to be back. Great to be back. Hard to believe it's been a whole year since we were here. Man, get to see all of you guys again and meet some new faces. Just really, really exciting. And I love this organization. Love working with Ralph Reed, and just his vision has just been phenomenal. So, man, what a great day so far. I got to hear from some great speakers, and the best is yet to come. Yet to come. So I'm really looking forward to it. So. Anyway, so I get to introduce our next speaker, and I was reading an article about him, and I want to make sure I get the headline right, so I'm going to pull my phone out, make sure I get the headline right here. It was a liberal New York reporter who was writing about Mark Robinson, and he said, Mark Robinson is MAGA's great black hope. They said the gubernatorial candidate has no experience and few accomplishments, but man, is he mad. Well, my response back to this reporter is, man, I'm mad too. And the American people are pretty mad too. If you're looking around, I mean, if you're paying attention to anything that's going on, if you've watched the news for 15 minutes, you're probably pretty upset about what's going on. And what I think we need is somebody like what Carrie Lake was talking about just a few minutes ago, is God give us some Davids, like 1 Samuel chapter 17, where he walked out and he saw all the soldiers and his brothers and everybody sitting on the sidelines. And he said, who is this uncircumcised Philistine that said he can defy the armies of the living God? And God give us some men and women and young people who will stand up to these godless reprobates and tell them, who are they to try to take our country away? Who are these people to try to take it away from us? You see what they're trying to fly these Palestinian flags on the Capitol. They're trying to defund the police. These guys, they're putting pornography in our schools, and somebody's got to say enough is enough. We're not going to take it anymore. And God give us some of those men here today. God give them to us. So, ladies and gentlemen, this is our country. This isn't an academic exercise. We've got to get involved. We've got to speak out. We've got to do something. Or else we're going to be living out those prophetic words from Ronald Reagan, where we're just going to be able to tell our kids what it was like to live in a place where we were once free. So I'm thrilled to death that we've got one of those men with us here today who about 6 years ago got sick and tired and fed up, got tired of the people on the sidelines, and said, you know what, I'm going to go and say something, and I'm going to do something about what's going on. He spoke up at the city council meeting, and he said, enough is enough. You're not taking our guns. You're not going to take away what our founders gave us, and I'm going to stand up and fight for our Second Amendment. And this guy has become a star. And you know, I know the reporter who wrote this meant it as a negative thing, but you know, maybe Mark Robinson is our great black hope. I mean, he's pretty great. He's done some great things as lieutenant governor. The rumors are true. He is black. And I hope to God he is our governor come November. Ladies and gentlemen, please welcome my friend, Lieutenant Governor Mark Robinson.
All right, we've been watching and listening together the Faith and Freedom Coalition Conference in Washington, D.C. Conservative Christian leadership making their messages known in the 2024 election. This is going to be going on all weekend in the nation's capital. Right now, we're squeezing in a quick break. We'll be right back with more headlines and breaking news stories on the other side of the break. I'm Keith Landry. Welcome back to Live Now from Fox. It's 11:09 on the East Coast on your Friday morning. It's 8:09 on the West Coast. And right now we're going to take you out to Santa Fe, New Mexico, where there's a hearing as to which folks will be allowed to testify in the involuntary manslaughter trial of actor Alec Baldwin in connection with the shooting death of a worker on the set. So we're going to take you out there right now. We're going to pull that up for you, and we'll listen in live together on this.
Interviewed all of the state's witnesses, despite the representation in the state's motion. In addition, the state also told the court and asserted that pursuant to Rule 5501, the state not only disclosed its witnesses, but also has provided the defense with all witness statements and experts' reports, as well as underlying data and a summary of proposed expert opinions. That is also false, Your Honor, because, and the court will see through different motions that are going to be presented before the court, some of which will come before the court today, and others which we will be submitting to the court later. In fact, that is not true. We had not received numerous expert witness supplemental reports. Those had been withheld from us, including one that was particularly exculpatory by Lucian Haig. That had not been provided to the defense as of the May 6th filing of this motion. There were also statements by the state's other expert, Brian Carpenter, that had not been provided to the defense. And to this date, we have, as of this day, we have made numerous requests of the state that they provide these statements that have been redacted through an IPRA request that we had done to try to get a hold of different statements from various witnesses and things like that, communications with the state. And so we are in possession of some emails, for example, email correspondence that does indicate that there are opinions of the state's witness, Brian Carpenter, and yet those have been provided to us in a redacted format through IPRA. So we do not have the ability to see the contents of these statements, but we can see that they exist. Now, there are many, many of these documents, and we don't know fully what might be contained within these various email communications and correspondences between the state and their expert witness. And we've asked the state, in compliance with their affirmative duty to provide statements of their witnesses and statements of their experts and opinions of their experts to the defense, we've asked them to provide unredacted copies. And the response has been, you know, you have to go ahead and identify for us which ones it is you need unredacted, and then we'll take a look at it. That's not how this rule works, Your Honor. The rule works that the state has a duty. They have a duty to go and look for and to exercise reasonable diligence to uncover statements and opinions of witnesses and expert witnesses, and they have an affirmative duty to provide those to the defense. And yet they're putting that burden again on the defense. We have also had disclosed to us over 150,000 pages of other documents. We had, as late as May 23rd, audio recordings that were taken by the state's investigator, Connor Rice, of various witnesses whom the state had listed on its witness list that we had never been provided. And we only received them on May 23rd. And the list goes on, Your Honor. It includes then the state has now filed, as the court is aware, is pursuing use immunity for Hannah Gutierrez-Reed. And in accordance with that, they have now provided over 361 recordings for our review based on statements that were made by Ms. Gutierrez-Reed. Now, the list goes on. There's more. There's more that has been disclosed and that continues to come. But these statements that the state has made in their motion as officers of the court are not true. These are factually not true. And so we are prejudiced. And this is why the doctrine of judicial estoppel would come into play, because this court needs to protect the integrity of the judicial process and prevent manipulation of the court system. And so when the court looks at judicial estoppel, it's a three-pronged test. The first two of which are part of the main test, if you will, and the third, while not necessary, is actually a part of the test that indicates that judicial estoppel is even more appropriate if that third prong is met. And so I'll go through those with the court now. The first is that the party against whom the doctrine is to be used must have successfully assumed a position during the course of litigation. The second is that the first position must be necessarily inconsistent with the position the party later takes in the proceedings. And then finally, while not an absolute requirement, judicial estoppel will be especially applicable when the party's change of position prejudices a party who had acquiesced in the former position. And so we'll start with the first prong. With respect to the first prong, Your Honor, the state has successfully assumed a position. The state took a position in a motion that witnesses should be excluded, and the defense, after full briefing of the case and in reliance on that position, the defense then conceded the state's the relief that the state had sought as to 5 of the 9 witnesses that the state was looking to have excluded. So the state was successful. In its motion, the state tries to indicate that that in fact, a party must have already had the matter adjudicated by the court in order for there to be a successful position that was taken by the court. I'm going to go to the state's motion. And so what the state says is that this must have already been adjudicated by the court in some way through some order by the court. There have been no arguments, is what the state says. The state says the record in this case is crystal clear. There were never any hearings or other judicial proceedings in which the state's initial motion to exclude certain defenses was adjudicated by the court. And therefore, their position is that that means that there was no, that we don't meet the first prong. However, that's incorrect, Your Honor. And if the court will look at the case that we cited, and it's Kuchan, which is a 2024 case, the site is 2024 NMCA 032. And when we look at this case in paragraph 14, the court notes that the respondent in that case did not successfully argue and therefore assume this position in a motion or at hearing. So the use of the word "or" clearly demonstrates that a party can assume a position either by its argument through a motion or also by its argument at a hearing. So it's either or. It doesn't have to be at a hearing. It can also take a position through argument in a motion. And this is further solidified through paragraph 16 of the same case. In paragraph 16, the court continues and states that the respondent could not be considered to have successfully assumed a position about the nature of the West Track until filing the motion for partial summary judgment. It doesn't say until argument of the motion. It says that upon filing of the motion for partial summary judgment, that is the moment at which the respondent could be considered to have successfully assumed a position. And that is what the state did in this case. They assumed a position in the motion that they filed, both the primary motion and then also their responsive briefing. They assumed a motion, or I'm sorry, they assumed a position. And they successfully assumed that position because the relief that they sought was granted effectively by the defense consent to that relief. The second prong, Your Honor, has, and I will actually point out the cases that the state cited for this principle. So that was the one that the defense cited. The state cited 3 cases in support of their proposal that that a motion has to be argued before the court and there has to be an order in order for there to be a successful assumption of a position. They cite O'Brien, they cite the Gabriel Vigil case, and then they cite a 2014 unpublished opinion, which is non-precedential. So I'll go over the 2 cases that are actually published case law. For O'Brien, In this case, this is a case where the court did apply judicial estoppel, and there did happen to be an order that was entered by the court. It was a pretrial order, but merely finding a case where estoppel was applied and where the court had entered an order does not indicate that the first prong can only be met where the court has entered an order, and that is not the holding of the case. It just so happened to be that in that case, there was an order that had been entered by the court, and therefore that met that part of the prong in the either or. So either in a motion or at a hearing. And so in this case, there was a hearing, and that was appropriate, but that does not say anything about the fact that one can also take a position through a motion. The Gabriel Vigil case, this one doesn't even deal with judicial estoppel. It actually involved the doctrine of collateral estoppel, which is a different doctrine. So collateral estoppel has a different test than judicial estoppel. And the purpose of collateral estoppel is to promote judicial efficiency and consistency. And the goal is basically to keep parties from relitigating issues from a previous suit. With judicial estoppel, we're talking about a purpose that has to do with protecting the integrity of the judicial process by preventing the parties from, and this is quotes from the various cases, from playing fast and loose with the court and ensuring that the party does not manipulate the judicial system. So in light of the fact that there is a 2024 case, which is the case that the defense cited, that precisely states that a party can assume a position pursuant to the first prong through motion alone, the question again is whether or not they were successful, and we submit to the court that they were. Now moving on to the second prong. The second prong says that the first position is necessarily inconsistent with the position that they take later. Clearly that is the case. Clearly that has been met. The state was first saying that there was prejudice by the inclusion of these additional witnesses on the defense witness list. The state's position was that those witnesses should be excluded. And now they have taken the exact opposite position, saying these witnesses should be able to be called by the state and there is no prejudice by their inclusion. Now, even though only the two prongs are actually required, the third prong again indicates that if the party's change of position prejudices the party who had acquiesced in the former position, then judicial estoppel will be especially applicable. And that is the case here. So the defense relied on the state's motion, which the state had told the court on May 31st in their notice of completion of briefing was fully briefed and was ready to be heard. And in recognition of that fact, and recognizing that we are scheduled for trial for 8 days, in an attempt to pare down our witness list substantially, we removed, again, almost half of the witnesses from our witness list, revealing significant defense strategy. And we also informed our witnesses. There were some witnesses who were scheduled to be interviewed the following day, and then a couple of days later. We informed those witnesses that they were released from their subpoenas. And we did, in fact, release them from the subpoenas, and we told them that those interviews would be canceled. We sent, again, courtesy copies of our notice to the state along with our amended witness list. And then that's when, within less than 3 hours after seeing defense strategy, the state changed its position. Now, the state proposes that really they can just cure any prejudice to the defense by extending deadlines. But that doesn't cure our prejudice for a variety of reasons. Primarily, because you cannot cure the fact that we have already revealed defense strategy in reliance on the state's position, and the state has now walked that back. We cannot cure that. In addition, we're in a time crunch at this point, Your Honor, and we do not have further time available. The state, in their motion on May 6th, noted that that they were prejudiced by the fact that there was only 8 weeks prior to trial. We are now in the position where we only have 2 prior to trial. We did not receive significant information from the state previously, and the reason that that is relevant here in particular is because time is a finite resource. The recordings alone that were disclosed related to Hannah Gutierrez Reed are so significant and substantial that if we take an average of the time that it would take to listen to each of the calls, and we dedicated one whole person doing nothing else, taking no breaks for a full 8-hour day, it would take that person approximately 15 business days to listen to the recordings. But we don't have 15 business days, we have 10. And not only that, we also then have to look at the potential of having to interview Ms. Gutierrez-Reed. So time at this point, Your Honor, is a finite resource, and the state is playing games to exploit that resource and to take time away from the defense where we should be spending our time in trial preparation. Instead, we are having to deal with the state's constantly changing positions, with their changing disclosures, with the new things that they're adding, and it's fundamentally unfair. And as the state notes in the state's own words, calculated sandbagging is not appropriate. And what they say in their own motion is that they say this kind of manipulation of the courts should not be permitted, and we agree. And so we are asking the court to therefore exclude the witnesses and to grant the defense motion.
I have a couple of questions before I hear from the state. First, you talked about that you decided that you were going to limit your witness list, cut it down because you had to switch gears for trial preparation. The time for investigation was superseded by preparation.
Okay, we've been watching live and listening live as the defense attorney right there for Alec Baldwin is trying to argue for a slate of jurors, or witnesses rather, that they want to be involved in this upcoming involuntary manslaughter trial out in New Mexico. So the judge is listening to her arguments. She's stating her case. We're going to come back to this after a quick break, but we do need to squeeze in a break here on Live Now from Fox at 11:26 on the East Coast, 8:26 out west. Come on back. We'll continue to see what happens with this hearing about actor Alec Baldwin.